Record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. I have two notes from jurors. The first one is from juror number 737, and it reads as follows: I need to speak with the judge about something. We're going to mark that note, Court Trial Exhibit 96, so C-TR-96. And then I have a note from juror number 640 that we're going to mark as Court Trial Exhibit 97, C-TR-97, that reads as follows. My mom sent me a text saying sentencing was this week, but I have not talked to her about anything. I did before it started that I had jury duty in Arapahoe County. That was all I told her. I also did not respond to her text and deleted it. I don't think we need to take any action with respect to juror number 640, but I think I need to bring in juror number 737 and see what he wishes to talk to me about. Is there any objection to me not taking any action with respect to number 640 on behalf of the people?
No, Your Honor.
On behalf of the defense, Ms. Brady? Okay, so we'll just proceed with 737 by agreement of the parties. Let's bring in juror number 737, please. The record should reflect that juror number 737 is now present in the courtroom. We're still outside the presence of all the other jurors. Good afternoon.
Go with that.
How are you?
I'm good. How are you?
All right, good. Thank you. You sent me a note that reads as follows. I need to speak with the judge about something.
Yes, sir.
And so what's on your mind?
Well, it's funny because I wanted to talk to you about it anyway, and then you said the thing right before we went in. I was really concerned because I got tweeted at over the weekend by someone I don't know with a linked article from Newsweek that mentioned me by name, like first and last name. So I didn't click the link to the article or anything. I didn't read it, but it brought up some concerns for me about media stuff in general. So.
All right, but you didn't read the content of the article at all?
No, there was a little blurb that just said that I was the foreman, and that was about it, but yeah.
Okay, and so you didn't read anything else?
Yeah, it just mentioned me by name.
Okay, all right. Anything about that you think affects your ability to carry out your duties as a juror pursuant to your oath in this trial?
Not at all.
Or in these proceedings?
No.
Not at all? Okay. Anything about that you think would affect you in any way as a juror in this case?
No.
Do you have any other concerns about that?
Well, I do, just in general about privacy in the media in general. I don't know if there's something you can do as the judge to, it was just weird to see my name there. That was not cool.
And as you know, I issued an order, as I informed you at the beginning of the trial, that prohibited the media from publishing any of the jurors' names. So,
right.
Okay. I'm going to have you step out for just a moment, okay? Thank you. All right. Any other questions or any other record that people want me to make with respect to juror 737? And then let's split it up into two. One is what action, if any, the parties think I need to take with juror number 737, and whether there are any other questions that you want me to ask. And the other one is with respect to Newsweek, and that's a separate issue. So, Mr. Orman?
To take any further action with regard to the juror. With regard to Newsweek, Gosh, Judge, I really don't know. I mean, if they violated an order of the court, and I say if because I really, I haven't read this article myself. And I don't know what, if any, information the person that wrote the article would have had about the court's orders beforehand or how they might have figured this out exactly. It seems like it's up to the court to take any action with regard to violation of that order. And if the court wants to do a contempt citation to have a hearing, I think that would be for the court to do. I guess that's all I have to say.
All right. Ms. Brady, anything with respect to juror number 737 in terms of whether you think I need to ask additional questions or I should ask any additional questions, or whether you think or are asking me to make any additional record?
Can I speak to the other lawyers for a moment?
Yes.
Thank you. All right, Your Honor.
Ms. Brady, any other record that you want me to make with respect to juror 737 on this particular issue, or are there any other questions that you are requesting that I ask?
If the court would just make sure that he hasn't told any of the other jurors about this, and assuming he has not, instruct him not to mention this to any of the other jurors. And that's all we're requesting regarding the juror. Regarding the Newsweek, we have located very quickly a Newsweek tweet that appears to be consistent with what the juror was describing. We'd like to make further record on that when we get a break. I don't think we need to do that right now, but we would like to make further record on that.
Okay. All right, let's bring in juror number 737 again, please. I think wait, hold on, sorry. I think that the request by Ms. Brady is an appropriate one. I'm assuming that people don't have any objection.
Not, Your Honor.
All right, let's bring him in. The record should reflect that juror number 737 is back in the courtroom again. One other question that I have is, have you told any other jurors about this?
Oh, no.
No. And will you promise me that you will not tell any other jurors about this?
Of course.
And will you promise me that you will not discuss this with any other jurors?
Yes.
And if at any point you have any other any concerns about this at all, will you promise me that you will indicate to my bailiffs that you need to talk to me?
Yes, of course.
Okay. Anything else that I can address for you?
That's it.
Okay, you did the right thing in letting us know. Thank you.
Thank you.
All right. The records reflect that juror 737 has now exited the courtroom. Given the record that was just made, I don't believe there's a request from either party from more questions or for any other record or for any action. Is that correct, Mr. Orman?
That's correct, Your Honor.
Is that correct, Ms. Brady? Yes, sir. All right. I suggest that we bring the jury in at this time so we can proceed with counsel's arguments. And then maybe after the break, if the defense wants to make a record, at that point the defense can, and we can have further discussion about the issue in terms of Newsweek. All right, let's bring the jury in, please. Thank you. Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Welcome back, folks. Thanks for coming back. At this time, we're going to proceed with closing arguments at the end of phase one. And we'll start with the prosecution. Mr. Orman, you may proceed.
Thank you. I'm going to talk to you, ladies and gentlemen, about phase one of the capital sentencing hearing in this case. And I'm going to talk to you about the 5 statutory aggravating factors that the judge just advised you about before the break.
Mr. Orman, is your mic on? There you go. Thank you.
Thank you. Did everybody hear me? Okay, everybody heard me, so I'm not going to repeat what I just said. First, I want to talk about the evidence. Because as the judge advised you, you can consider most of the evidence that was presented to you in the first part of the trial, all 250 or so witnesses that you heard, with some exceptions. The judge told you about some evidence that was admitted solely for the purpose of determining the defendant's sanity. You cannot consider that. But you can consider all the rest of the evidence, and there were some limiting instructions for that you can consider for a limited purpose too. For instance, some statements and emails that you can consider for the purpose of figuring out what the response to the email meant. You can use that evidence in these proceedings, but not the evidence that was admitted solely for the purpose of determining the defendant's sanity. That is not admissible in this phase, and if I'm talking to you about inferences from evidence, I'm not talking to you about that. I'm talking to you about the other evidence. So I want to put in context these 5 statutory aggravating factors and the evidence that you have heard. So let's talk about aggravating factor number 1. And you have that instruction, but I just sort of typed this out from that instruction, that the defendant intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed 2 or more persons during the commission of the same criminal episode. So intentionally, that was the same culpable mental state with another part of attempted murder, a murder after deliberation. And then you have this knowingly with universal malice. That's the same culpable mental state that you had with murder, extreme indifference. And then killed 2 or more persons during the commission of the same criminal episode. The defendant killed, and you have convicted him of killing Jonathan Blunk. The defendant killed, and you have convicted him of killing A.J. Boyk. The defendant killed, and you have convicted him of killing Gordon Cowden. The defendant killed, and you have convicted him of killing Jesse Childress. The defendant killed, and you have convicted him of killing Jessica Gowie. The defendant killed, and you have convicted him of killing John Larimer. The defendant killed, and you have convicted him of killing Matthew McQuinn. The defendant killed, and you have convicted him of killing Michaela Medic. The defendant killed, and you have convicted him of killing Alex Sullivan. The defendant killed, and you have convicted him of killing Rebecca Wingo. The defendant killed, and you have convicted him of killing Alex Teves. And the defendant killed, and you have convicted him of killing Veronica Mosier Sullivan. The evidence has shown you that the defendant killed 12 people, murdered 12 people in the course of a single criminal episode. We have proven to you, beyond a reasonable doubt, statutory aggravating factor number one. Statutory aggravating factor number two, that the defendant intentionally killed a child who had not yet attained 12 years of age. So let's talk about this a little bit. Intentionally means it was his conscious objective to achieve that specific result. His conscious objective to kill a child who had not yet reached 12 years of age. Well, what do we know about that? You remember the testimony of Dr. Learcall that Veronica Mosier Sullivan had 4 separate gunshot wounds to her little body, and that she was 6 years old. She was shot 4 times by the defendant. 4 times. When you shoot someone 4 times, you do it with intent. And you have the conscious objective to kill them. Also, the evidence shows you that the defendant had the conscious objective to kill everyone in the theater, man, woman, and child alike. And why do I say that? You heard about the hundreds of rounds of ammo that the defendant took to that theater. You saw all of those magazines that he had on him, all those magazines filled with bullets that he had on him. That he went in there with 3 weapons. The handgun, the AR-15, and the shotgun. He went in there with enough firepower and enough ammo to kill everybody. And that's what the evidence shows you he intended to do. And how do we know he intended to kill a child? How do we know that? Well, I'm going to ask you to go back a long way. This trial's been a long trial. I'm going to ask you to go back all the way to April 28th. And you heard from a witness named Chi-Chi Sproul. And what did she tell you? She told you that that theater was packed with kids. Not only that, she said she'd never seen a theater with more kids in it. And if she wanted to sit away from kids, she couldn't find a spot. It was hard for her to find a spot away from kids.
Excuse me, object, misstatement of the evidence.
Members of the jury, remember that you determine what the evidence is. The attorneys can make arguments and they can disagree on what the evidence was. You need to rely on your own memories of what the evidence was. So the objection is overruled with that cautionary instruction that you're not bound by the arguments of counsel. You need to rely on your own memory of the evidence. All right, you may proceed.
Think about the testimony of Corbin Dates. You all got to remember Corbin Dates. And what did he tell you? He told you that there was a baby, a little baby, in the same row that the defendant was in that theater.
Judge, objection, misstatement of the evidence.
Same ruling, same cautionary instruction.
You heard the testimony about little Mr. Rurs, 3-year-old kid who was in that theater. Again, lots of kids in that theater. The defendant had the intent to kill every single one of them. We have established beyond a reasonable doubt that he intentionally killed a child who had not attained the age of 12 years. Aggravating factor number 3, that the defendant in the commission of the offense of murder in the first degree knowingly created a grave risk of death to a person in addition to the 12 victims of the crimes of murder in the first degree. A grave risk of death to someone other than the people that he killed. Well, there's Theater 9. Did the defendant create a grave risk of death to everyone in that theater? I submit to you the evidence shows he did. He brought that gun in there. There he is with that gun, strapped right here. He brought that rifle into the courtroom. And there it is, lying on the ground outside the theater, out back, with the blood of a victim or victims of a gunshot wound right there. He brought in a magazine that could hold 100 rifle rounds. 100. And he used steel penetrator rounds. And there they are, right there on the floor with those green tips to kill as many people as he could. He also used that shotgun found in the theater right there, and he used that handgun found on the top of his car. And there's all his implements together on the bed, the handgun you can see at the bottom, and the shotgun and the rifle at top. And these are the items that he used to knowingly create that risk that someone else might get killed other than one of the victims of murder. And let's talk about what evidence was found in the theater, because that's important too. 65 shells for 223 rounds. 5 shells for 40 caliber handgun rounds. And 6 shells for shotgun rounds that each held 100 pellets. So you add all that up, that's at least 76 shots inside the theater. And if you count those shotgun pellets as individual projectiles, which you should, because you saw the way that they spread out and the damage that they did, 670 individual projectiles shot in that theater. Here's the shooting incident reconstruction that Mr. Mills, the FBI expert, showed you, and this is every round where they could find a trajectory in Theater 9 and going into Theater 8. Did that create a risk of death to someone other than a homicide victim? I submit to you it did. Here's one of the rounds, went into that metal pole, created that hole. Person shooting that off in a theater, is that creating a grave risk of death to everybody in there? I submit to you it does. This is another diagram. It's kind of hard to see up there, but maybe you can see it here. This is the shooting incident reconstruction for rows 8 and 9 in that green trajectory. And let's take a look at some of the damage to row 8 there. Those are the rods. Those are the rods from the bullet trajectories in row 8. Grave risk of death to everybody in row 8. I submit to you the answer to that is yes. Row 9. Look how low they are there. Grave risk of death to everybody hiding on the floor. I submit to you yes. That is the back of his in row 9, going through the back of the seat. Grave risk of death. Here's another one. There's the seat bottom in row 9. Look at these holes. Look at what that rifle did. Went through that seat like a hot knife through butter. Grave risk of death. There's a diagram for row 10. You can't see it up there very well. It was better on my computer. You have that back there to take a look at. And there are the rods for row 10, and you can see them for row 11 too. Grave risk of death to everybody there. I submit yes. There's a row 11 seat bottom. You can see that bullet hole. Row 19, almost up to the top. Seat bottom. Grave risk of death. I submit yes. Everybody in Theater 9 that wasn't killed was in a grave risk of being killed, and he knowingly did that. Even going into Theater 8, there's that hallway on the side of Theater 9, the wall going into Theater 8, the trajectory rods. And there they are on the other side, in Theater 8. I'm going to have to click this one manually. And there is the diagram in Theater 8. And as you can see, one of those rounds went all the way across, and you heard somebody got shot way on the other side of Theater 8. Well, I think this ran out of batteries, so I'm just going to do this manually over here. Okay, so consider the injuries. Consider the injuries that you heard about to the people in Theater 9 and Theater 8 in determining whether the defendant created a grave risk of death to these people. And I'm just going to show you some of them. Heather Snyder, grave risk of death. Zach Goldich, grave risk of death. He was in Theater 8. Petra Hogan, grave risk of death. Jameson Toes, grave risk of death. Farah Soudani, that's an injury to her legs. Is that a grave risk of death? And you remember the testimony, how her organs were literally pouring out of her body and had to be held in by hand. Grave risk of death. Caleb Medley, he came in here, you saw him. Grave risk of death to him. Dion Rosborough, grave risk of death. Stephen Moten, grave risk of death. Aden Avia Ariando, grave risk of death, shot in the leg. Yusuf Garbi, grave risk of death. Lean Young, grave risk of death. Bonnie Kathleen Poroso Zogby, and you'll remember her, she came in with the flowers in her hair. Grave risk of death. Ashley Mosier. I know you all remember Ashley Mosier. Grave risk of death to her in the theater. I submit to you there is a grave risk of death to any of them and all of them and everybody else in Theater 9 and everybody else in Theater 8, and that we have proven to you that statutory aggravating factor. Here's the next one. Statutory aggravating factor number 4. That the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. And the judge gave you an additional instruction on this, that the prosecution must prove beyond a reasonable doubt that the defendant committed the offense in a conscienceless or pitiless manner, which was unnecessarily torturous to the victim. And you got to consider this individually for each person he killed. So let's talk about that. A conscienceless or pitiless manner, which was unnecessarily torturous to the victims. Were these offenses committed in a conscienceless or pitiless manner? I submit to you the evidence shows that they were. They were. How about unnecessarily torturous to the victim? Well, let's talk about what that means. I would ask you to consider the circumstances of these murders and how that shows you that they were committed in an unnecessarily torturous manner. See, not every murder is going to be unnecessarily torturous. You could kill someone, I guess, in a humane fashion. Were these murders committed in a humane fashion? Or were they unnecessarily torturous? Consider, the defendant modified the environment of the theater by deploying tear gas. There's a can of tear gas right there, clear out. There were 2 cans. This is the one that was found outside. This means that, and you can make a reasonable inference based on the evidence and what you heard happened in that theater from many people, that the victims would experience extreme discomfort from the tear gas in addition to being shot. Is that unnecessarily torturous? I submit to you it is. I submit to you it is. The defendant killed his victims in a crowded movie theater. Now that in and of itself might not be torturous, but think about what that means and the implications of that. They were trapped in there by design. And why do I say by design? Because of the tear gas. And because it's dark. And because it's crowded. They were trapped in there and they couldn't easily protect themselves. And the tear gas made it hard for them to move. Some unable to flee, and you heard lots of testimony about that. Lots of testimony about that. In darkness. In darkness. And they knew, they would have had to know, any human being would know, that there was nothing they could do to protect themselves. Nothing they could do to stop him from killing them, and that death was imminent. so they could think about it. I submit to you that is mental torture. I submit to you that is unnecessarily torturous, in addition to all the images that you saw of how these people died. That is unnecessarily torturous. I would also like you to think about the fact, or the inference you can make from the evidence, that at the moments of their deaths, the victims would not only be in fear for their own lives, but in fear for the lives of their friends and family and loved ones. And I submit to you, that's even worse than being in fear that you're going to die yourself. That you're afraid that your fiance or your child or your mother is going to die there with you. Unnecessarily torturous. They died, and you know this because you've heard the evidence, surrounded by screaming and by pain and by anguish. That is how they died. That is how he killed them. Dying like that is unnecessarily torturous. It is conscienceless. It is pitiless. It satisfies that aggravating factor defined by statute beyond a reasonable doubt. Let's take a look at the last aggravating factor. Aggravating factor number 5, that the defendant committed the offense of murder in the first degree while lying in wait and from ambush. Lying in wait, ambush. So I'd ask you to consider these victims of murder, the 12 victims of murder, before the defendant came into that theater armed with 3 firearms, they were unaware of any danger. How could they be aware of any danger? They were watching a movie in a movie theater, a place of enjoyment and safety. And they were helpless to do anything about what was about to happen to them. And the defendant was in a place of concealment, lying in wait, ambush. That's the place of concealment right there. You heard lots of testimony from lots of people in the theater that the defendant went in through that door. You heard lots of testimony from police that found him outside that door, at his car. You saw this. You actually have this in evidence, this clip that the defendant put on the door to keep it from closing all the way. This place of concealment, of hiding, of lying in wait to kill people who had no idea that anything was coming. They had no way to know. They could not know, unless they were somehow psychic, that danger stood right outside that door. The defendant went through that door, and he came in right there through that door, and then they knew. And then they knew, but they couldn't do anything to protect themselves. And then the killing started. The defendant came from a place of hiding and killed people who had no idea that danger was coming. That is ambush. That is lying in wait. And we have proven to you beyond a reasonable doubt that that this aggravating factor is present for each and every count of first-degree murder. We have proven to you that all aggravating factors applicable to each count, because there's one aggravating factor only applies to 2, are present. We have proven that to you. And this is unlike the first phase of the trial where we would ask you to find the defendant guilty. You've already found him guilty. What we're doing here in this phase 1 is asking you to go back there and find that these facts are the truth. That they are the truth.
I'm going to object to the truth. Can we approach?
I'll sustain the objection. Why don't you rephrase, Mr. Orman?
That all of these factors are present beyond a reasonable doubt. I'd ask you to go back there, talk about it, discuss it, but decide that that is the case. Fill out those jury verdict forms and come on back here saying that that is in fact the case. Thank you very much.
All right, thank you, Mr. Orman. All right, Ms. Brady, is there a closing argument on behalf of Mr. Holmes at this time?
Your Honor, the defense has no argument regarding Phase 1.
Okay, thank you. All right, folks, given that there is no argument by the defense, that also means that there is no rebuttal closing by the prosecution. So with that, I'm going to send the deliberating jurors to deliberate. Please remember all my admonishments. In terms of the alternates, you cannot have any contact with deliberating jurors at this time until I tell you otherwise. Now, we're not going to send you to the room where you were before during the trial, but you'll be in the other two jury rooms, but there will be no contact between the deliberating jurors and the alternate jurors at this time. Okay? Does everybody understand that? Okay, so I'm going to have the alternate jurors leave the courtroom first so we can escort you, my staff can escort you to your rooms. Folks, please keep in mind all my admonishments and make sure you do not deliberate at all. You cannot deliberate either with each other or even internally about anything related to the case, okay? All right, thank you. And for the record, the deliberating jurors are now exiting the courtroom. Excuse me, the alternate jurors, sorry, thank you. The alternate jurors are now exiting the courtroom with my admonishments in mind. And we'll have lunch brought to them. All right, for the record, the alternate jurors have now left the courtroom, and so let me again address the deliberating jurors. We're going to take you back to the courtroom 201 jury room so you can start deliberating. Remember that you can only deliberate when you're in the jury room and all of you are present, okay? All the exhibits that you're able to consider are back there in the room or already there. My staff took them there during the lunch break or during the closing arguments. We'll have lunch brought to you, and then make sure you follow all my admonishments during deliberations. Do not have any contact with the alternates at all, okay? All right, folks, you may retire now to the jury room for Division 201. The record should reflect that the deliberating jurors have exited the courtroom now. What I propose is that everyone get their lunch break, and then if you want to meet after the lunch break, we can talk at that time, Ms. Brady, okay? All right, let's take, is an hour enough? Let's plan to have counsel back here at 2:30, okay? 2:30. All right, the court will be in recess. Thank you.